Thank you, Jeff. I assume that means you didn't read the bios.
No. Well, if you have anything.
No, I'm just kidding. By the way, I wish in 1991, when you gave that talk and wrote that article, you had been more persuasive. It might have helped us all.
Me too. Well, I should point out, I was debating with Steve Salzberg, then the deputy assistant of the criminal section, at Cato. I guess that was the problem. It was at Cato, right?
All right, I'll take that under advisement. My name is Bill Lytton. I'm currently senior counsel at Dechert LLP, but I've done some other things that I suppose make it relevant for me being here. Let me just give you a quick background, and then I'm going to ask you some questions, so pay attention. First of all, I'm standing up because once I had to attend a mock program that the ABA was putting on the trial of patent litigation, and Judge Merritt from the Eastern District of Virginia was the moderator, and we were sitting around in a conference room around a table, and it was my turn, and I said something, and Judge Merritt says, "I can't hear you." And so I spoke louder, and he said, "Stand up when you address the court." Okay, I'm in jeans, so I will stand for this. I started out working on the Hill for a United States Senator in the 1970s, and in that time period, I worked on the Watergate matter from the Senate side, anticipating a prosecution of the president on impeachment. I also worked on the independent counsel statute, some early drafts of that back there in the mid-70s. From there, I became a federal prosecutor here in Chicago for about 3.5 years, and then I was a federal prosecutor in Philadelphia for another 5 years, where I was various things, including chief of criminal and the first assistant U.S. attorney. I might add that when I was chief of criminal and first assistant, I was not yet 30 years old, and I was making some of those decisions that Alice was talking about with almost no real-world experience to speak of. And I used to say when I would address judges that I think it was fair to say that I probably put more people on probation than you did in terms of whether or not to prosecute somebody. As in the example of, for instance, let's just say hypothetically you had a governor of Illinois who was having lunch with somebody who wanted to be a contractor in the state of Illinois, and a discussion evolved about money passing hands. Somebody has to decide if that's Hobbs Act extortion or mail fraud. And you know who decides that? It's the prosecutor, and it really just depends which one you want to get. So you decide which is the victim and which is the criminal. So those are decisions I made as a young assistant U.S. attorney, and I must say when we were in Chicago, we didn't really pay much attention to Washington. We didn't really think we were part of DOJ. We didn't tell them that. After that, some 8.5 years as federal prosecutor, I went into private practice. I was a trial lawyer. I did some criminal defense work. I did some civil work. And then I did some work at the White House. I went down to work with President Reagan on Iran-Contra after the scandal to coordinate the response to the various investigations of that. Then I went to in-house, and I've been in-house, I actually added this up, amazing, 18 years. I started off in GE Aerospace, which was a defense contractor. That then was sold to Martin Marietta, which then was merged with Lockheed to form Lockheed Martin. So I spent a fair amount of time in the aerospace industry. Then I became general counsel of International Paper, and then in 2002, I got a phone call and foolishly said yes. Not foolishly, it was a good thing. I became general counsel of Tyco International Limited after Mr. Kozlowski had been escorted off the premises. And I did that for 5 years, and then I retired 2 years ago and became senior counsel at Dechert. So I've had a variety of experiences, both from the prosecution side, from the scandal side, from the public investigation side, from the inside, and from every other part of the way I can think of. And I think I may be the only one who will speak to you today who's had the inside experience. I may be wrong on that. But I did want to ask the folks in this room, you're all judges. I assume that means you're all lawyers and good ones. How many of you have actually, when you were in your private lives, had actually represented human beings? Just raise hands. Great. Terrific. How many of you represented the fiction, the corporate fiction? Somewhat fewer. Okay. How many of you have worked in a corporation as a corporate lawyer? All right. Got about 5, 6. And how many of you have actually run a for-profit organization? 1, 2, 3, 4, 5, 6. Not bad, but probably less than 10%. That's good because it gives some perspective. Most of you had as much experience with corporations as I did when I was a young assistant U.S. attorney, but some of you had more. Let me talk about what it's like inside a corporation, sort of from the other end of the kaleidoscope, when you're faced with all of the things we were talking about today. It's a little bit different. We do have the responsible corporate officer doctrine, and I should point out that probably technically I was a responsible corporate officer at several corporations. Indeed, at Tyco, I had environmental health and safety reporting to me, which was probably a mistake, but it worked. Let me describe, by the way, Tyco. When you think about a corporation, I doubt anybody here knows anything that Tyco makes or any services. We don't make toy trucks. A lot of people think they do. I always said to the CEO, maybe we should buy that company. We had 250,000 employees doing business in 120 countries around the world with 250,000 employees and 2,300 corporate subsidiaries. That was the organization, the corporate structure that we had, which made it somewhat interesting to come into the corporate level when I got there, when the CEO, the CFO, and the GC, all of us who had been preceded, were all under criminal indictment. We were suing them and we couldn't talk to them. And there was literally no one at the corporate level in the corporate offices. When I got there, I became general counsel. I looked around, and there was one person who was the paralegal, and she was leaving that day. I got her to stay. So within that context, you have to think about the corporate responsible corporate officer doctrine and the public welfare doctrine, all of which has been spoken of today. And what has been talked about is this tendency towards criminalization. And when I last did this program with Henry about 5 years ago, we talked about it then, and it's gotten very interesting, even more so since then. I think it's gone from criminalization to demonization. And I think that is not necessarily a good thing for corporations or the public, but that's where we are. Let me talk about the political environment that we operate in, because the political environment is the larger ocean in which the legal environment floats. We're in a populist tsunami over the last decade, and certainly within the last couple of years. On September 24th of 2008, the Wall Street Journal, just as the financial crisis was breaking, the headline was, "Pressure is on FBI, regulators, to hold executives accountable." What does that mean? To put pressure on the FBI, criminal prosecute. Federal law enforcement, according to the Legal Times in February 2009, wanted to prosecute and focus on gatekeepers, and especially lawyers, because, as Neil Barofsky said, they have most to lose, they're the most likely to flip, and they make the best examples. Senator Patrick Leahy from Vermont was even more blunt. He said, "I want to see these people prosecuted. Frankly, I want to see them go to jail." Barney Frank, one of my favorite congressmen, scheduled a hearing for last month, and he said at this hearing he wanted to discover from SEC and DOJ, and this is a quote, what their plans were to prosecute irresponsible and in some cases criminal behavior. Quinnipiac says the public's current attitude is let's burn a few bankers alive. Senator Charles Grassley suggested that AIG executives should commit suicide. Obama said people have a right to be angry. I'm angry. 20 state attorneys general have issued subpoenas for AIG employees, some of them who live in my town in New Canaan, Connecticut, and their homes have been picketed and they've gotten death threats. So that's kind of, the political environment we live in. And of course, we've had a lot of stand-up politicians and media saying that's wrong to do that to those AIG executives who had nothing to do with it. I haven't heard them, but I'm sure they do. One of my favorite movies is Young Frankenstein, and you may recall Inspector Klemp in there when he says, "A mob is an ugly thing, and it's just about time we had one." We have one. Now, Norm Augustine, who was the former CEO of Martin Marietta and then Lockheed Martin, had a wonderful saying. He said, if the only tool in your toolbox is a hammer, every problem looks like a nail. And the problem we now have is that from a prosecutor and regulator's point of view, they think that every problem is nailed because the only tool they have in their toolbox is the hammer of prosecution. And that has resulted in some of the things we're doing today. So, what does that mean inside? We have malum prohibitum and malum in se. Malum prohibitum almost doesn't apply in anything malum in se doesn't apply to anything we're talking about here. And I know all of you are law-abiding. There is a sign outside as you came in that says no food or beverage is allowed. How many of you brought in water or something to drink today? Come on. Right. I saw one judge ask you to look at the sign and walk out and put it down. But that's malum prohibitum. And a lot of the rules and regulations we're dealing with are in that context. The EPA regulations, I think there's 17,000 pages of EPA regulations, more than are in IRS. And we expect the plant manager at Bastrop, Louisiana, in a paper mill, to have mastered those and understand them and make sure he doesn't screw up, because he is a responsible corporate officer and can go to jail. In law school, we all thought, well, the Constitution was kind of divinely inspired, and we had wonderful judges to interpret the law and great legislators who reflected the public will and limited government in the way that it was being executed. That is no longer the case. We are stuck with and facing individuals, whether they be prosecutors, regulators, or whomever, who are making life and death decisions about individuals and corporations, Arthur Andersen being an example, and they have no experience, frankly, in doing this. When you have Elliot Spitzer, God rest his soul, as one of the most despicable attorney generals and governors, I think, in the way he handled himself, not with the prostitute. I once was at a meeting in Atlanta, and he was on it, and I was asking about attorney-client privilege. I said, and I'll get into this in the next panel, but I said, when you demand that somebody give up attorney-client privilege, do you consider the centuries by which this philosophy has evolved and what impact you may? He said, I don't know, I don't care. I don't care, I just want to convict somebody. And that was his process. You know what AG stands for? Aspiring governor. And that's, you have now people on the state side and in the federal who really are running for political office and using these things and responding to the media in a very dangerous place. The marketplace that we are, thinking about when we're in a corporation are worried about what's going to happen to our stock price, to our employees, to our corporation. What happens when you want to train people? Most of the people who work in a corporation are honest people. They want to do the right thing. I guess that most of them don't know that they can go to jail for doing something or for not doing something that they didn't intend to create any harm. At Tyco, when we trained people in environmental law, we told them that each of the following actions could be pursued criminally. Intentionally storing hazardous waste but didn't know it required a permit, intentionally transporting waste without a manifest but don't know it's hazardous, intentionally discharging tank bottoms but don't know that it will violate a permit. It was kind of tough to get people to take that job. Think of Mr. Hanasek, the fellow out in Alaska who I think he was actually asleep when that happened that night, when the fellow rode off the board and broke the pipeline. How would you like to then go up to the next person to take that job and say, look, Hanasek's just gone to jail for 6 years. Would you like to take that job? You might have a little difficulty getting him to do it. But we are into the point, I'm reminded of Oliver Twist. You remember when Mr. Brownlow says to Mr. Bumley, the law assumes that your wife acts under your direction. Mr. Bumble says, if the law supposes that, then the law is an ass, an idiot. If that's the eye of the law, then the law is a bachelor, and the worst I wish the law is that his eye may be opened by experience. Now, it's probably politically incorrect, but the same thing now applies to our employees. The law presumes that they know the law. And if you look at the two theories we were talking about, it's not a far cry to take toxic waste and make it a criminal action to toxic assets. I would argue that the impact, the negative impact of what has happened in the financial community is much more severe in individuals than the leakage of that oil up in Alaska that Mr. Hanasek went to jail for. Who is going to advise their client that that's not the next criminal situation, that intent will be nothing, it'll be a general intent crime that you'll have to deal with? When we train our people, we try and train them to do, this was when I was at Tyco, tried to train them in the right way to do things. We spent a lot of time and effort to do that. We had to be incredibly loud sometimes. We had to make them believe that what we said we believed, and we had to give them all of the technical understanding that they had to have. But just as some of the other panelists said, the odds of us with 250,000 employees not having one that was going to violate the law were zero. I used to argue to the government, I only want you to know what we do so that when something bad happens, you'll be as surprised as I am. Because that's all I could ask for. When you talk about a global and a multinational corporation, go try speaking to your employees in China, you're speaking to them through an interpreter, who have a Thai manager, who report to a regional manager out of Australia, who are working at a business out of Paris, and you're trying to tell them not only what the law is, but how important it is that they have the right ethical and integrity aspect. And you have no idea whether you're making an impact because their eyes are blank. You can't judge it. So it's a very, very challenging environment that we all work out there in. When a case comes in to a corporate general counsel's office, how does it come in typically? I get a call, I'm retired now, but when I was there, and it says internal audit has picked up something, we got an anonymous letter, and we have a problem. We look at it. But maybe I should first call Alice and say, Alice, I've got a nutty letter. I have no idea if it's true, but I want to make sure we get credit for voluntary disclosure, so I want to let you know right away. So what does she do? She opens up a criminal case folder, U.S. versus Tyco, right? Now it's already been categorized that. I go back a couple of months later. We looked at it. It's nothing. Nah. Then I have to do a civil settlement with her. I'm not saying Alice. Alice is like all of us. Alice is like all of the federal prosecutors. It takes us a little while to cross the aisle and realize that when we were there, everything was done right, but now, who knows who's running the place. But you get that case in, and let's assume that there is a problem, and you have to make a decision. Do I want to go up to DOJ and make the disclosure? What's going to happen? It will get in the paper. I will have to spend an awful lot of money with the government, either in a fine or instituting some new programs, which I'm going to do anyway. Once it gets public, I'll have my favorite class action lawyers, those that are not currently in jail, coming after me. Mel Weiss, I had to sit across the table from Mel for a long time until he went to jail. And so I have to deal with that. My competitors from France, they're not going to make that disclosure, so they're not going to have these problems. And I've got to decide, what do I do? And a lot of corporate lawyers these days, both inside and outside, are saying, maybe it's not in the best interest of the corporation to make that disclosure. Why? Because the penalties, the negatives of that are so draconian. Now, I always made a disclosure, especially when I was at Tyco, because I didn't want to be in a position of finding either a news leak or a whistleblower who goes in and tells them, and I have to explain why I didn't go in. I mean, frankly, that's why people do it. But that is a real-life situation. So now I've got a problem. I've given it to Alice in her former life, and I'm dealing with the criminal guys, and then I get a call from the suspension and debarment people. Maybe I get a call. What I probably get is a notice in the mail telling me that I've been suspended. The corporation has been suspended. Why? Because they don't have to follow due process. They don't have to tell you anything. In fact, one of the chief suspension and debarment lawyers from the federal government once said, I don't like to give notice in advance to somebody I'm going to suspend because then they get the lawyers involved and it gets really messy and just slows things down. And it's not just defense contractors. You may be a sub of a sub of a sub providing hamburger buns to Lockheed Martin, and you may be suspended from providing those hamburger buns. Or you don't provide anything that goes into a military contract to Lockheed Martin, but if you're on the suspension list, they don't want to have anything to do with you because that will impact their corporate responsibility from a suspension and debarment authority. So you're dealing with the suspension and debarment authority who have no concept of due process. You're trying to resolve the criminal case, and then Mel Weiss or whoever walks in, and he says, by the way, I want $50 billion. And I say, but you've only got a 10% chance of winning. And the only reason you have 10% is because our name is Tyco, and people think we make toy trucks and are crooks. And he'll say, okay, 10%, $50 billion, give me $5 billion, and I'll go away. And you know what? That's not a bad deal. That's not a bad deal if that eliminates that 10% possibility of a $50 billion risk to the corporation. So when I look at all of this and how it kind of comes down on the individual in the corporation or the plant manager, the criminal area is important, the impact on the corporation is important, the impact on the people who live and work next to me is important, but oftentimes what scares me just as much as anything else is the civil side. Now, having said all of that, I want to ask you a question. Assume that you are now back in private practice. You got a terrific pension from the bench, hopefully, and I'm your client. And I come to you and I say, Judge, because I still call you Judge, the advantage of being a speaker here with all of you is I know all of your first names. It's Judge. I say, Judge, I just got this call from this headhunter, and they want me to come in and take over Fannie Mae. How many of you would suggest I take that job? None. Stacia Kelly is a good friend of mine. She's the general counsel at AIG. one of these days she'll probably leave. I get a call and I say, Judge, they've asked me to be general counsel at AIG. How many of you would suggest I take that job? Now, nobody's raising their hand. And I think that gives us pause. It should give us pause, because there are two reasons that you're not doing that. One is you think I'd be lousy at the job, and I take that as a possibility. Or you may think that no matter how bad or good I may be, if I were your client, you would not want to tell me and recommend that I take the risk that goes with that, criminally or civilly. The former dean of Georgetown Law was on the board, I think, was it of Enron? Was she on WorldCom? And she did a deal with the now disgraced head of the pension fund in New York, Mr. Hevesy, and he demanded that every member of that board personally pay a fine, unreimbursed by insurance. So now I give you a call and I say, I've been asked to be on the board at Tyco. How many of you think I should take that job? And by the way, the New York Pension Fund invests in our company. You're not going to do it. And if that's the case, and I think somebody mentioned this before, the risk is that really good people who we want to get involved and run these companies and set the right example and be evangelical in the way they talk to their employees and make sure that they make money for their shareholders and do it right and obey the law, they're going to sit this one out. They're not going to do it. And we have to ask ourselves, I think, have we gotten to a point where we need some more tools in the toolbox other than just a hammer? Thank you.